Counsel, I'm Loginsky. Thank you very much for this opportunity to speak to you. I'm ready to hit the Court of Appeals running, and I can do this because I'm extremely qualified for the job, and here's why. First, I know the workings of the court. I know its role in the judicial process. I clerked for Robert Windsor, Court of Appeals, judge. Second, I've argued in excess of 300 cases in the Washington Court of Appeals and the Washington Supreme Court. I've written hundreds of briefs that have been successful in both courts. Third, I've been involved with laws from soup to nuts. I've written statutes, I've shepherded them through the legislature, I've implemented the laws, and I've defended the statutes in the appellate courts. I serve on the Washington Supreme Court Committee that's responsible for updating and writing the pattern jury instructions. And fourth, in my current role as the staff attorney of the Washington Association of Prosecuting Attorneys, I advise prosecutors throughout the state on such diverse subjects as police procedures, Native American law, Public Records Act, and constitutional law. I look forward to answering your questions about my qualifications and background, and I want to thank you again in advance for your time and your attention.
Thank you. I'm Tom Bjorgen, also a candidate for the State Court of Appeals. What I'd like to do in this introduction is to give you an idea of my view of the appellate court system. Before doing that, though, just one quick update. My endorsements are on the website, but a few have come in the last week. I want to mention two former Chief Justices of the State Supreme Court, Gary Alexander and Robert Utter, have endorsed. And the Kitsap County Bar Poll, which was issued last week, did go in my favor for what that's worth. I think that the appellate courts, when they do their job correctly, can almost serve as the conscience of the country or the state. And that's because the appellate courts have in their care the foundational principles that make this country something to be proud of. Principles like the freedom of speech, the freedom of religion, the idea that everybody's entitled to fairness, the idea that everybody is of equal stature under the law. Now, does the system always work well in protecting those rights? No, it doesn't. It has its stumbles and its fumbles. But I think it's important to keep in mind that the ultimate goal of this system is the just and the principled and the humane application of the law to the facts of our lives. So we need judges who will have the courage to make the hard decisions needed to protect those rights, but we also need judges who will observe proper judicial restraint and who will not step over that line into the legislative sphere and start striking laws down because they disagree with them. And in closing, perhaps above all, we need judges who will remember that this notion of justice underlies everything that we do, and that justice is not going to be justice if it depends on who you are or who you know or the size of your bank account or the weight of your influence. If I am elected to this position, those are the principles I'll do my utmost to follow, and I hope there'll be an opportunity to go into my experience and background through answers to questions. Thank you.
Well, why don't we go right into that then? One thing that we sometimes ask is, tell us some things from your own personal background that help kind of craft who you are and who you're going to be on the bench. Obviously, you're following the law, but also your personal experiences do play into who you are. And so tell me a bit, maybe some of the things that you've been most influential in your life that have helped kind of lead you to this position. I'll let Tom.
Well, I can tell you a little bit about what I did before I became an attorney, because I think that can be instructive. As a young person, I spent a lot of time working in the orchards and warehouses of the Yakima Valley. That's where I grew up. Later on, I became a park ranger up at Mount Rainier, and was also a school teacher in Norway, in the public school system over in Norway for a year and a half. And those experiences, I think, have informed what I am as a lawyer, because they give some knowledge of how the decisions we make as judges touch the world outside the courthouse walls. And I think that those experiences, together with what I've done as a lawyer, are important and describe the sort of judge I would be. And just very briefly, I've been a lawyer for over 30 years. My first legal job was with the State Attorney General's office. In that position, I wrote briefs on behalf of the state of Washington in 3 cases in the U.S. Supreme Court. and I argued cases in the Federal Ninth Circuit, the Federal District Courts, State Supreme Court, and the State Court of Appeals. I went on to become a senior deputy prosecuting attorney for Thurston County in the Civil Division. I largely did land use and environmental law for the county. And for the last 13 years now, I've been a partner in a law firm in Olympia and engaged in private practice. My principal clients there have been individuals, organizations, and businesses in the area of land use and environmental law. I'm also the general counsel for intercity transit as part of my private practice. And maybe most pertinent to this position, I've been a hearing examiner for the city of Olympia for about the last 12 years and for Thurston County for the last 2 or 3 years. And as I expect everybody knows, a hearing examiner is basically an administrative law judge who decides cases in the area of land use permitting. So you have a written record of decisions that you can look at. You don't have to take my word when I say I would be impartial, but you can look at those decisions and you can tell from that, I think, you can see a record of impartiality.
I was raised to believe in public service and community service, and from the age of 14 I've been involved in volunteer work of all kinds. I think it was the day after my 14th birthday I showed up at the hospital to start candy striper training. I served in the United States Navy as a hospital foreman, joined the Navy right out of high school. I never thought that law would be a career for me. I'm an accidental lawyer. When I left the Navy, I moved back to Washington State, been stationed at Whidbey Island, and fell in love with the beauty of the place. And while waiting to establish residency for college, I started volunteering in a shelter for battered women. And that led me to work with the Bellevue Police Department back before mandatory arrests, so we're talking early 1980s, dealing with domestic violence response. And they had one of the first diversion programs, very similar to kind of drug courts and those other programs where they look at treatment rather than punishment to try to get to the root problem. And participating in that program, I did the statistics for them and kept track of how things were working. I rapidly discovered that the prosecutor was the person who could put those kind of programs together. If the prosecutor is not interested, you can't have a therapeutic program. So I went to law school to become a prosecutor. I worked my way through law school, working graveyard as a medical lab technician. And I went to law school since I knew I wanted to be a prosecutor, and I had worked with crime victims and I worked with police officers. I decided it was important to work with prisoners. And so while I was in law school, while working full-time, I also participated in the Prisoner Counseling Project. And that sends you out to the prisons to help the inmates with legal issues ranging from civil through criminal. I clerked at the Court of Appeals right out of law school and then joined the Kitsap County Prosecutor's Office and was there for about 10 years. Prosecuting attorneys, unlike any other kind of attorney, are quasi-judicial officers. We owe as much duty to the defendant as we do to the crime victim and the rest of the public. And I was taught that very early and have watched out for defendants' rights. Washington is one of the only states that fully implemented counselor notification, which is this right, if you're not a U.S. citizen, to be told if you're arrested that your consulate officer might be able to help you. And Washington was at the vanguard of ensuring that that treaty right for defendants. And that was partly taught to me, that importance, by the judge I clerked for, who had the state constitution on his desk at all times.
With a background mostly on the prosecutor's side, that you said not only did you work there, but that's kind of was the genesis of you getting involved in law. If you're in a judge's seat, how do you put yourself in the position of a defendant? Do you have experience doing that? How do you think you balance those two things out? Because you wouldn't want to lean towards this is what I know, and so that's what my mindset is.
Well, and I can answer this in two ways. First off, over half the caseload that comes to the Court of Appeals is criminal law. And we have seen cataclysmic changes in criminal law in the last 5 years. The U.S. Supreme Court rewrote Confrontation Clause, search law, sentencing law. Prosecutors every day have to step back from being an advocate to being that disinterested person, because we have to decide, if the police didn't seize the evidence correctly, we won't file charges. If it's clear cut, we are not going to file charges because we're not going to yank someone out of their life into the criminal justice system. When the appellate courts say, okay, prosecutor, you did something wrong, or legislature, you didn't correctly reenact a statute, it's our obligation to go find the defendants who are in prison serving sentences under those statutes and release them. And so that's always been and is always part of a prosecutor's role. And I can tell you that there are defense attorneys who have endorsed my candidacy because they know I can be fair and that I have that ability to step out. But on top of that, the Washington Supreme Court has appointed me on 2 different committees where you have to be a neutral and detached decision maker. One is on the Pattern Jury Instruction Committee. On that committee, I don't get to say, this is what prosecutors want the murder jury instructions to say. I have to say, this is what the law indicates those instructions should say. Whether I totally agree that that's the best language from my side or not. I've also served on the Practice of Law Board. Practice of Law Board had adjudicatory responsibility to determine whether someone was engaging in the unauthorized practice of law. We also had to issue advisory opinions as panels, just like you do at the Court of Appeals, as to whether something constitutes the practice of law. And in both those cases, I'm in that neutral and detached decision maker role.
So, it's the same question.
Sure. I think impartiality is one of the key essential attributes that we need in judges. And I've gotten to know Pam in the course of this campaign, and I have no question but that both of us would do our level best, our good faith best, to be impartial in every case we decided if we were on this court. I think it's also the case, though, that nobody is a blank slate. We all bring to what we do our background, our experiences, and our inclinations, and those can have an effect on what we do as judges, whether or not we know it. I think one of the principal safeguards in our system against that sort of unintended effect from our background is to avoid imbalances on our appellate courts. Right now, in Division 2 of the Court of Appeals, if we don't count Judge Armstrong, who is retiring, there are 4 judges who have strong criminal prosecutorial backgrounds. To add a 5th judge from that, with that same background, even somebody, and I say this genuinely, whose impartiality I trust completely, as I do Pam's, but to have 5 out of 7 judges coming from the same background, criminal prosecutorial background, I believe is the sort of imbalance that ought to be avoided in an appellate court, especially when the appellate court makes its decisions in panels of 3. There are going to be too many panels with 2 or with 3 former prosecutors.
Pam has experience working with the prison population, it sounded like, other kind of victims. Your experience is more some city law, some hearing examiner, land use, and things like that. What about your background as far as getting in the shoes of a defendant or a marginalized population, so you can feel those things? I think that's kind of just so we can understand what's in your background.
Absolutely. I have tried in my professional life to do a lot of pro bono work in volunteer legal services. In the 1980s, when I was an assistant attorney general, I did pro bono work for the then Puget Sound Legal Assistance Foundation. That has been reorganized into another group now. But I did pro bono work for them. In the 1990s, I was on the board of directors of the Government Lawyers Bar Association, among other organizations. And one of the things we did with government lawyers was to cooperate in the founding of the Volunteer Legal Clinic in Olympia, That is an organization in Olympia that has volunteer lawyers who are present, and they will talk to people who are marginalized, as you say, who don't have the means to hire a lawyer, but who have the need for a lawyer. And they will do their best to connect those people with that need, with individuals with lawyers who are able to serve them. I also volunteered for a long time at the Bread and Roses Kitchen for the Homeless in Olympia. This unfortunately has ended now due to budgetary problems, but from the late 80s, I would say, to around 10 years ago when it closed, I volunteered there serving food to the homeless population. Doing that, I got to see the homeless population close up. I also was a member of Olympia Kiwanis and worked on their garden, which raises food for the Thurston County Food Bank. Over the last 10 years, what I've tried to do in an informal way in Olympia is to see if I can give some help to people whom I talk to on the street who are homeless. This began with just striking up a conversation probably 15 years ago with a fellow who was obviously in distress on the street. And I found that I was able to, if nothing else, apply a Band-Aid on occasion by buying this person dinner, by getting him a hotel room when the temperature was 20 degrees in the wintertime. And I've tried to do that just on an informal basis. This isn't part of any organization over the last 10 years. And it is striking what can be done just by a little goodwill like that.
Tom is saying that could be a weakness of the court to have too much prosecutorial experience on there, and I would imagine you disagree with that.
I disagree with that on a couple of grounds.
I'll let you do a quick answer to that first, then I had a follow-up question.
One of them, Judge Armstrong, who I'd be replacing, comes with a criminal prosecution background also. Second, if you look at the opinions of the Court of Appeals, even panels with 3 people who had prior prosecutorial experience, they're not being reversed for pro-government decisions. Their decisions when reviewed by the appellate court are as likely to be reversed when they were in favor of the defendant as when they were in favor of the state. They're likely to be affirmed in both. And again, prosecutors are the only people with that quasi-judicial background who have that obligation under the professional rules of professional responsibility and the case law to be neutral and detached.
My follow-up question is there a weakness on the court as far as whether it's how it's set up, who's on there right now, and I'm not asking you to pick people particularly, but is there a weakness that you feel that you can come in and fill with your expertise and your background? I'm
not so sure there's a weakness. What I can fill, here's what the problem is with the Court of Appeals. They have a crushing caseload right now, and the legislature recognized this and approved another position quite a few years ago, which they can't fund. And I don't think any court should be going to the legislature right now saying fund this position when there's so many other needs. But what it means is you need someone who can step in and immediately start handling 70 to 100 opinions a year. I can do that. Not only have I argued a lot of cases and briefed a lot of cases, but it's current. I have already argued 1 case in the Washington Supreme Court this year. I'll be arguing 2 more before Election Day. I have had 46 opinions that are published where I have either been counsel of record for a party or counsel of record for a friend of the court, issued since 2001. I believe the last published opinion that Mr. Bjorgen has been involved in was issued in 2001. And so some of the things that I can bring is the experience with a large caseload. When I was the appellate attorney for Kitsap County, I handled 70 to 100 cases a year. I bring current knowledge of the hot issues on the court. I bring a very strong work ethic, very strong familiarity with the rules of appellate procedure, and in addition to my criminal law background, when I was a deputy in Kitsap County, I did dependency proceedings. I did mental health commitment proceedings. My amicus briefs aren't just in criminal law. They're also in land use, public records, road closures and vacations. So I've been involved in a large area of law, which will help me to put out to meet that output that's needed for timely decisions.
Tom, if she's correct that there is this really heavy caseload right now and you're going to be extremely busy, what is it about you that helps answer that question? And then I'll give you a chance that if you think there's another weakness that you particularly feel, I'll let you ask that second.
There are distinctions between Ms. Loginsky and me, but the ability to step in and handle the caseload is not one of them. When one works in private practice, as I have for the last, well, I've been a partner for the last 13 years, in private practice for 15 or 16 years, one stays busy, and one always has clients who are paying you and who are demanding service, who are demanding a result. That is a difference between public service or public practice and private practice in law. In private practice, you have the individuals who are paying you out of your own pocket, and there is no, at least that I've found, there is no more potent incentive to keeping up on things, to handling the caseload. That coupled with the fact that my appellate work, as I mentioned, does extend into the U.S. Supreme Court and at the Federal Court of Appeals, Federal District Court, and the state appellate courts, shows the ability, I think, to step in right away and handle the caseload. As far as fitting any need at the Court of Appeals, I would point out that, yes, Judge Armstrong does have a criminal prosecutorial background, but I took a look at the court website today, and that was only in the first several years of his practice. Since I believe it was 1970, Judge Armstrong has been engaged in a largely civil practice. And of course now he's been on the bench. I think the package of experience that I bring, public practice and private practice, appellate work and trial work, experience in various different areas of law, including mental illness commitments, which was mentioned a moment ago, duplicates or tracks, it doesn't duplicate, but tracks much, much better what Judge Armstrong will be taking from the court when he retires. And Judge Armstrong, again, has endorsed me to succeed him, and the quote, the statement that he gave, now to be completely accurate, this was in the primary election when Judge Armstrong endorsed both me and Mr. Weaver. His statement was that Mr. Weaver and I were by far the most qualified candidates to succeed him. Mr. Weaver obviously is no longer in the race.
Pam, in your answer a moment ago, you said that you know what the hot issues are. Will you tell us what, in your opinion, what are, give us maybe the top three, and then we'll let Tom use.
Top three issues right now is when and under what grounds and to what extent can police officers search vehicles at the roadside, whether it be search incident arrest or impound inventory search, and that's being argued in the Washington Supreme Court October 4th. But it's just an indication of where we're going. We're going to, can you get a search warrant by email at the roadside? How long, if you impound a vehicle for a search warrant, can you hold a vehicle? So that's a whole major area right now. Another major area deals with Confrontation Clause. When can someone testify about what someone else said outside of court? You know, it used to be general indicia of reliability. Now it's testimonial, non-testimonial, and there's all sorts of issues when the defendant threatens a witness or induces them not to appear. Another major issue is the U.S. Supreme Court just this last term said there cannot be mandatory life without possibility of parole for people under the age of 18 who commit murders. This community has Michael Monroe Furman, who had been sentenced to die for a murder he committed before his 18th birthday, who now potentially is a beneficiary under that decision. And how is that decision going to be implemented? Is it going to be legislative that makes the decision? Executive branch, as the governor giving clemency, judicial, and how is that going to be balanced?
I take a somewhat broader view of the principal issues facing the appellate courts. First of all, in the area of criminal law, as you all know, we have in the state and the country what's called the exclusionary rule, which basically means that evidence which is seized or obtained improperly is not admissible. This rule is probably necessary as a way of enforcing these laws, but it comes at a great cost because it means that evidence which is probative, which does speak to the truth, is excluded if it was improperly seized or taken. Because of that, I think that because of the effects of the exclusionary rule, I think that judges are under a real obligation to make their pronouncements on the criminal law and criminal law rules just as precise as they can, to give as precise a set of guidance as is possible to law enforcement. Now, courts cannot issue advisory opinions, which means they cannot make a ruling in a case that's not before them. But I do think that courts can do more to give precise guidance to law enforcement as to exactly what is allowed and what is not allowed. Another issue, which is a fascinating one, is, and this applies both in criminal and civil law, is the ongoing effort to adopt, or adapt, I should say, principles which were adopted in the 18th century, our grand constitutional principles, to a world of just rushing technological change that was not anticipated or contemplated in the least by the founders of our country. And that is one of the great challenges, but also one of the great beauties, to use a metaphor, of our common law system here, that we are constantly faced with new circumstances, and judges need to apply these ancient principles to these new circumstances in a way that takes into account the new world basically we live in, but at the same time ensures those principles are vindicated. And you asked for three. I'll try to be a little briefer here. The third issue I would raise is what oftentimes is called access to justice, and that is we have an adversarial system here in our country, and what the premise behind that system is the idea that truth will come out and the best interpretation of the law will come out if we have two parties that go at it in a way, that put on their case, bring their witnesses, bring their evidence, make their arguments. But if one party can't afford a lawyer and the other party has the best of lawyers, well, that system is distorted. And this happens time and time again. I have no pat answer to this. I mean, things such as better funding of legal services would help. Measures such as more use of alternative dispute resolution, such as mediation, which I've done quite a bit of, would help. Measures such as the Bar Association prodding lawyers more to give pro bono services, that would help. But there's no panacea here, but it is a central issue.
Anyone else like to ask the question?
Yeah, I'll ask one. I go back to the original statement there, which I found interesting, that the appellate court should be the conscience, which implies conscience is based on moral principles. So, I'll ask this question for both of you. Do you believe that the business of the appellate court is to provide a strict interpretation of the law, or should there be a moral aspect to the decisions which may or may not be open to interpretation?
The law is about what is allowed and what is not allowed. So it does have a similarity to moral principles, because that's the business of morality too. I think judges, though, need to be very cautious, especially in injecting their own personal ideas of morality into the work they do. Because the job of the judge is to, well, there are a number of jobs of the judge, but to determine the facts, to interpret the law, and then to apply the law to the facts. And the central pole star, mixing metaphors a bit here perhaps, in doing that is not whatever the judge's personal idea of morality is, but the purpose, the legislative intent behind whatever the law is that the judge is applying. And that's what has to guide the judge. My remark about conscience was not meant to imply a deviation from that, or that we want judges to try to enact their own personal moral codes. No, not at all. My reference to conscience more was to bring out that there are occasions in our history where an appellate court has made a decision that would not have been made by any legislative body, a decision that the majority of people in the country would not have agreed with, such as in 1954 when the U.S. Supreme Court said racial segregation in our public schools is unconstitutional. Even though that was unpopular, even though no legislative authority would have made that decision, the U.S. Supreme Court did make that decision, not on the basis of personal morality, but on the basis of implementing the Constitution the way it ought to be implemented. That to me is what I meant by conscience.
The Court of Appeals is an error-correcting court. The Court of Appeals doesn't determine facts. That's done in the trial court. And the Court of Appeals' role, we're sandwiched between the Superior Court and the Supreme Court. And our role is to accept and apply the precedent from the higher courts, accept and apply the statutes from the legislature unless they're constitutionally infirm, and to give full force to the Constitution of the state of Washington in the United States. And sometimes that will result in an opinion that if we were just looking at morality, you'd have trouble justifying. As a young law clerk, I had a case where there was a sex offender who years later was civilly committed as a sexually violent predator, but a mistake had occurred in a probation violation proceeding. And the law required me to recommend that he be released, that he be given relief. Morality would probably have argued against that because of the possibility of creating another victim. And my role as a judge is to follow the law. And then, I lived in dread of reading a newspaper about that other victim, but that wasn't the role I was supposed to be serving at that point. And I hope that answers your question.
Well, the argument that you stated for the under 18 mandatory life sentence, doesn't that involve some moral aspects?
Yes. The question, though, as to how those moral aspects will be decided is for the legislature. In Washington, under our Constitution, the legislature determines the sentencing availability and the process, and the courts have to comply with those unless they're unconstitutional. So some relief has to be given and will be given. And the questions will be, how will the three branches work together to reach a decision that matches the conscience of the community, and that conscience will be expressed through the legislative process.
Do either of you have any experience in family law?
The only experience I've had with family law is in the domestic violence arena, advising individuals both about how the different court orders impact firearm ability. I will be honest with you, I read every appellate decision. I've never determined the child support schedule. I've never, fortunately, had to make that tough decision about how to allocate parental time. I have worked to make it as easy as possible for people to represent themselves in those situations. I have worked with the Pattern Forms Committee to develop forms that can help walk individuals through when they don't have an attorney.
I have not practiced in family.
Mr. Bjorgen, I note from the Voting for Judges website that you haven't received a rating from either Q-Law or the Cardozo Society. Why is that?
I have requested a rating from Q-Law and also from the Asian Bar Association. And there is a interview which I just yesterday found is going to be scheduled for October 18th, which is a bit late in the process, but nonetheless, I will go through that. The Cardozo Society, I just have to admit that was an organization I wasn't aware of. And if I were doing it again, yes, I would have. I just was not aware of that.
And Ms. Loginsky, do you have any civil trial experience? No?
I did a jury trial for civil commitment. I have done,
Just as a Kitsap County prosecutor?
yes. And I have represented a prosecutor in an action involving an injunction from a police officer that was resolved on summary judgment.
I wonder what either of you think. You both gave us your list of what you think the hot issues are. I'd like to hear what each of you think about the issue of closed court proceedings and whether or not the appellate courts have resolved that issue, and if they have, if they've struck the right balance.
If I may respond to that, the Article 1, Section 10 issue is hot. There's tons of cases in the courts right now, and I regret to say that the appellate courts have not been doing a good job of dealing with the issue with regard to their own courts. One of the cases that I am involved in, the appellate court sealed portions of the appellate court record without engaging in the exact same balancing act that they want the trial courts to engage in. I think that's unconscionable.
I think what you're telling us, though, is that in an instance it's not being done right. What I'm interested in knowing is whether or not the guidelines that have been established are settled, and if so, if they're adequate.
They are not settled, and I don't believe the court has adequately given balance as to which factors you should address. The Supreme Court has said it's a balancing test. The only ground they recognize right now for closure of any kind is the defendant's right to a fair trial. That means that if you have a civil case involving abuse, nothing can be sealed. If you have a juror who is asked an honest question, have you experienced sexual abuse, so that they can serve on the jury, the court has said there has to be this procedure, but they haven't said if the privacy interest of the juror will be enough to seal. So there is a lot yet to be done.
I would agree that the area is far from settled, and that the application of the guidelines is far from settled. We are under a rule here prescribed by the State Supreme Court in the Code of Judicial Conduct that says we cannot give an indication of how we might rule on a specific issue that might come before the court. So I am not going to tell you how I might rule on specific factual circumstances that could be posed. But I do agree with what Ms. Loginsky said about the need for more precision and probably some adjustment in these guidelines.
I'm going to ask you a question that kind of tiptoes around with what you're just saying with respect to the things you cannot comment on. I was interested in just hearing from each of you. Give me a decision by this particular court that has surprised you in recent years. And I don't mean surprise as though you're having to say, I disagree and would go the other direction, but maybe something you thought, that's interesting, that was interpreted differently than I had been in the past, but maybe something specific from that court that caught your attention.
Yes, I can give you an example. I suppose there are many examples. One that is in an area that I practice in quite a bit is land use law. There was a case in 2002, there were actually two cases, the Benchmark and Isla Verde, which adopted the rule that a land use regulation, I'm simplifying somewhat, but the basic rule was that a land use regulation in a specific case could only be enforced if that regulation was proportionate to the burden that was caused to the property owner, and that burden was proportionate to whatever good or purpose was served by the land use regulation. This was in the context of a requirement that a subdivision dedicate 30% of its land to a open space. And not surprisingly, the state Supreme Court said that that was disproportionate, that there was nothing caused, there was no impact caused by this subdivision that in any way justified such a disproportionate dedication of a third almost of the property to open space. That was not too surprising, but what was surprising was that the Supreme Court did not put any limits on that. And now we are finding in land use law the argument being raised time and time again that any land use regulation is subject to this proportionality requirement. So we are having people argue, for instance, that a wetland buffer requirement, let's say 100 feet, just to make it a little bit more concrete, can only be enforced if there is a showing that that specific development is causing a risk to the wetland for which the 100 feet is needed. What that does is it does away with the ability of local governments especially to adopt generally applicable setback requirements, including the very conventional and long-standing zoning requirements of setbacks from property lines. What surprised me with that decision was that the state Supreme Court made a decision in a specific case which made sense, this 30% open space dedication, but they did not go on to give any guidance as to where the limits of this rule was. And now I am afraid it is just spawning a lot of litigation, a lot of expense, and it will come back to the state Supreme Court for a real resolution.
I think one of the decisions that was surprising only in that I think it changed a long-standing practice in a lot of communities was the Court of Appeals not too long ago said the pay or be jailed procedure that many counties across the state had implemented to encourage criminal defendants to pay restitution and legal financial obligations was being administered in an unconstitutional way. And the decision, I think, was solid. But what was surprising was it took one so long for the issue to reach the appellate courts. And then two, how dramatically it changed the procedures that different communities were using.
I'd like to condense something which has been talked about off and on throughout this session. My question is, do you agree, or not, pardon me, do you consider that the appellate court is functioning effectively, and if so, what added value are you going to bring to the court over and above what it is now? Or do you have some fundamental difficulty with the way the court's operated, and what are you going to bring that's going to help correct that imbalance?
I don't see a problem with the court. I think the court is functioning quite well under a grueling workload. What I hope to bring to the court is the ability to produce opinions timely. Every bit of delay from a case being brought to the appellate court to the decision is a business owner who can't complete a business deal. It's jobs that aren't being made. It's a dissolution that's in limbo, and child custody that's in limbo. It's people's lives in limbo. What I have been rated by 4 separate bar associations as exceptionally well qualified to sit on the court, and well qualified by 3 I have already been rated by the Joint Asian Judicial Evaluation Committee. One of the things that I would like to bring to the appellate court in Washington, many jurisdictions have the problem of individuals who can't afford an attorney at the appellate level. And what many courts have done is they have paired with local law schools to give law students an ability to get appellate practice and to provide counsel for litigants. And that is something I would like to explore with the law schools and hopefully get in place.
Sorry. I agree that there's not a fundamental problem with the Court of Appeals, the way it's doing its business, but I do think there are some things.
That's the wrong word I use, is fundamental. Like, do you see any deficiencies anywhere in the way the court operates or decides? And what are you going to bring to correct that?
Thank you. I do have some suggestions, some ideas of things that can be done differently, especially to perhaps process cases more efficiently, more quickly, because it is a crushing workload that this court is under right now. First of all, the judges on this court now live from Bainbridge Island to, I believe Judge Johansson lives in Longview. Judge Penoyer is in Raymond or South Bend. I think the court needs to make more use of the technology which is available for carrying out conferences and research via electronic means. This will save on travel costs, it will save on time costs. I think it will allow some gain of efficiency in what the court does. I am not arguing, though, for holding argument, the actual oral argument via video conferencing or Skype. No, I think that's best held in person, but there is a lot else that can be done using the technology we now have available. Secondly, there is a statute that requires the Court of Appeals to give its reasons in detail for every decision it makes. And with most of the decisions it makes, perhaps the vast majority, that's an essential rule, because the Court of Appeal and appellate court in general sets precedent. So it's essential that the reasons for its decision be made. But the court also makes a lot of very routine decisions, almost clerical decisions. And I think there is a possibility for allowing a class of decisions to be made without the need for this detailed statement of reasons. It's worth talking about. It's worth exploring whether or not that is the case, because I think that could save a lot of time and save a lot of effort. I would try to bring that to the court. The other thing, which I guess I've mentioned, but just to restate it, because you did ask what we bring personally. I think the experience, the background that I would bring best fits, best parallels that which Judge Armstrong will be taking from the court when he comes.
Let's bring it to a close. Let's give each of you a chance to kind of leave us with a closing statement. If there was anything that we weren't able to touch on that you wanted to make sure we know about, or anything else you'd like to say in leaving us. I think we started with Pam and Tom, so we'll go the same order as we finished. Go
Okay.
ahead.
A few things in my background that we didn't talk about that I will bring to the court. I have served as a special deputy prosecutor in over a third of the counties, and I have trained police officers in every corner of this state, from the big urban areas to the small rural areas. And that gives me an understanding of how the court systems work in the one judge counties, how they work in King County. I also have taught police officers not just continuing education, but at State Patrol Academy. I'm teaching my 11th class right now, which I'm honored to do because it's their 100th class. And so I have proven ability to take these appellate decisions and convert them into understandable rules that the police officers can enforce at the roadside in seconds. And I will bring that to my writing. Those are the two things I don't think I was able to touch on before. I would appreciate your endorsement. I would appreciate your vote. Thank you.
We have a magnificent principle at work in this country. It's called the rule of law. We're not subject to the whim of kings or tyrants. Instead, we're subject to law, a law that ultimately the people have adopted. And it's not just any law, though. It's a law that attempts to protect these fundamental rights that I mentioned at the outset. It's a law that attempts to treat everybody fairly. It's a law that attempts to view everybody of equal stature under the law. And to be a part of that from the judicial, at the judicial level, would be a high privilege. That is what draws me to this more than anything else. And I think the combination of life and legal experience that I've talked about, and that you will see on the website in more detail if you'd like to take a look at that, is precisely suited to serving those goals. Words are cheap, though. I mean, any candidate is going to stand here and say that he or she will be fair and will protect rights and constitutional rights and all this. It's important for you to hear us say that because we're saying it sincerely, but you don't need just to take my word for it. As I mentioned, I've been a hearing examiner for 12 years. And it's not the case that the prosecutor is the only attorney position that is quasi-judicial. Hearing examiners are also. And you will find in my written decisions over this 12-year period a written record of what I think is impartial decision-making. In fact, about 3 years ago, my tenure as hearing examiner in Olympia was challenged by somebody who said I was biased. And this person said that I was biased against development interests. And so I went back and I looked at every decision I had made as hearing examiner for the city of Olympia. And the percentage was it was between 80 and 85% of the decisions I made were approvals of the development proposal. So that ended that attack. I think that and the decisions as a whole show the type of impartiality that I would bring to us. And I also would appreciate your endorsement. Thank you very much.
Well, thank you both for coming. I certainly appreciated that.